The appeals court just delivered a crushing blow. 3 federal judges unanimously denied Trump's petition for a rehearing on presidential immunity, sealing his fate for trial. And this isn't some procedural setback or routine legal maneuver. This is the complete collapse of his last constitutional shield against federal prosecution, triggered by a 47-page filing so airtight that even conservative legal scholars couldn't find cracks in the reasoning. When federal appellate judges use phrases like frivolous and without merit to describe a former president's claims, you know the walls are closing in fast. Hit that subscribe button right now because you won't want to miss any of the videos I release. So, what led to this devastating legal defeat? Trump's attorneys filed emergency motions claiming absolute immunity from prosecution while serving as president, arguing that Jack Smith's election interference case should be dismissed entirely. This wasn't just another delay tactic or standard criminal defense strategy. This was a constitutional Hail Mary designed to place former presidents above the law permanently. And the court's response, a unanimous rejection so swift and decisive that legal experts are calling it unprecedented in modern presidential history. It's honestly hard to believe we're watching the final constitutional barriers crumble around a former president in real time. Here's the full picture of what's been unfolding. Tensions between Trump's legal team and federal prosecutors have been escalating for months, fueled by increasingly desperate immunity claims, emergency appeals, and repeated attempts to delay the March 4th trial date. But everything reached a breaking point on January 9th when the D.C. Circuit Court of Appeals issued their initial immunity ruling, finding that former presidents enjoy no special protection from criminal prosecution for unofficial acts committed while in office. The ruling, written by Judge Karen Henderson and supported by Judges Michelle Childs and James Pan, systematically dismantled every pillar of Trump's immunity defense. The court found that executive immunity doesn't extend to criminal acts, that the presidency doesn't grant blanket protection from prosecution, and that allowing such immunity would place presidents above the law in direct violation of constitutional principles. This wasn't about policy debates or executive privilege boundaries. It was about whether any individual, even a former president, could claim complete immunity from criminal accountability. Smash that like button if this is making sense so far. Here's where it really gets serious. When Trump's attorneys reviewed the 57-page ruling in their law offices, they recognized immediately that standard appellate arguments wouldn't be enough to overcome the court's comprehensive legal reasoning. And let's be honest for a moment. Petitions for rehearing en banc are extremely rare in federal courts. They don't happen over routine disagreements with legal interpretations. They happen when attorneys believe a 3-judge panel has committed fundamental errors that warrant review by the full appellate court. Here's what multiple sources say happened next. On January 16th, Trump's legal team filed a 23-page petition for rehearing en banc, arguing that the panel's immunity ruling conflicted with Supreme Court precedent and created dangerous precedent for future presidents. The petition included emergency requests for expedited consideration and stays of all trial proceedings until the full court could review the matter. The filing process itself revealed the desperation within Trump's legal strategy. Court clerks reported that Trump's attorneys submitted multiple draft versions throughout the day with last-minute revisions that suggested internal disagreement about legal arguments. One court employee speaking anonymously to Politico described the final filing as unusually frantic with formatting errors and inconsistent legal citations that typically indicate rushed preparation. Sources familiar with the filing told CNN that Trump attorney John Luro personally drafted sections arguing that the panel had misinterpreted Nixon versus Fitzgerald, the 1982 Supreme Court case establishing presidential immunity for civil lawsuits. Luro's argument relied heavily on dicta from Justice Powell's majority opinion, attempting to extend civil immunity protections to criminal prosecution despite clear constitutional distinctions that legal scholars immediately identified as problematic. Meanwhile, co-counsel Todd Blanche focused on separation of powers, arguments claiming that allowing criminal prosecution of former presidents would weaponize the Justice Department against political opponents. Blanche's section included alarming hypothetical scenarios where future presidents could face prosecution for routine executive decisions, though legal experts noted that such scenarios deliberately ignored the distinction between official and unofficial conduct that the original panel ruling had carefully established. The coordination effort extended beyond Trump's immediate legal team. By January 18th, the full D.C. Circuit had received supporting briefs from conservative legal organizations and former Trump administration officials. The Federalist Society submitted an amicus brief arguing that broad immunity protections serve essential constitutional functions, though their argument notably avoided addressing the specific criminal conduct allegations at the heart of the case. Former Attorney General Bill Barr, despite previous criticism of Trump's election claims, filed a statement supporting limited review of the immunity questions. Barr's position created particular tension within conservative legal circles, as his previous statements had acknowledged that Trump's post-election conduct crossed constitutional lines. Legal observers interpreted Barr's filing as an attempt to preserve executive power precedents rather than defend Trump-specific actions. The petition claimed that without en banc review, the panel's ruling would irreparably harm the institution of the presidency and set dangerous precedents for partisan prosecution of former presidents. Legal reporters who obtained the full text noted that the language was unusually stark, with Trump's team arguing that the ruling represented an existential threat to executive authority and the peaceful transfer of power. Drop a comment right now if you saw this coming. I read every single one. Now things get absolutely explosive. When that petition was reviewed by the full D.C. Circuit, even Trump's most reliable judicial allies couldn't find legal ground to stand on. Conservative Judge Neomi Rao, who had previously ruled in Trump's favor on executive privilege matters, remained silent during the rehearing deliberations. The bombshell moment came when Chief Judge Sri Srinivasan announced the court's decision just 72 hours after receiving the petition. Legal reporters in the courthouse say the speed was virtually unprecedented for such a significant constitutional question. The court didn't just deny the rehearing request. They rejected it with language so definitive that appeal experts immediately recognized it as a complete legal dead end. That's when it became clear this isn't just another appellate setback. The denial came with a 1S sentence order that legal scholars are calling the most significant moment in presidential accountability since United States versus Nixon. The petition for rehearing en banc is denied. The court wrote, no member of the court requested a vote on the petition. When even conservative judges appointed by Republican presidents refused to grant a hearing on presidential immunity, it signals that the constitutional arguments have collapsed entirely. This move sent shock waves through Trump's legal strategy team. When a full federal appellate court unanimously refuses to even consider rehearing immunity claims, it means the underlying legal theory was so fundamentally flawed that no judge found it worthy of serious debate. This isn't the first time presidential immunity claims have faced judicial scrutiny. Think back to Richard Nixon during the Watergate scandal when he claimed executive privilege to withhold tape recordings from federal prosecutors. The Supreme Court unanimously rejected those claims in United States versus Nixon, ruling that executive privilege couldn't overcome the demands of criminal justice. Nixon resigned 3 weeks later rather than face impeachment and prosecution. Then there was Bill Clinton's attempt to delay the Paula Jones civil lawsuit using executive immunity arguments. The Supreme Court rejected those claims in Clinton versus Jones, ruling that sitting presidents weren't immune from civil litigation for acts committed before taking office. The decision established that presidents don't enjoy blanket immunity from legal accountability. Subscribe immediately if you haven't yet. This content doesn't exist anywhere else. And let's not forget Trump's previous immunity claims during the Manhattan District Attorney's investigation. New York's highest court rejected those arguments, ruling that former presidents have no special constitutional protection from state criminal prosecution. Even Trump-appointed Supreme Court justices declined to intervene when the case reached the High Court. Now, however, it's different. This time, we're dealing with federal prosecution for acts allegedly committed while serving as president. The strongest possible case for executive immunity under any legal theory. The pattern is clear. When presidents claim immunity from legal accountability, even sympathetic judges eventually recognize that the rule of law applies to everyone. So what specifically triggered this unprecedented judicial rejection? According to constitutional law experts, who reviewed the D.C. Circuit's original ruling, Trump's immunity arguments violated fundamental principles that date back to the founding of the Republic. The court found that absolute immunity would transform presidents into monarchs, precisely what the Constitution was designed to prevent. Professor Lawrence Tribe of Harvard Law School told MSNBC that the Rehearing denial represents the final nail in the coffin of imperial presidency theories. He explained that the court's unanimous position demonstrates that even conservative judges understand the dangerous precedent that would be set by granting absolute immunity to former presidents. Here's the kicker. The denied petition included explicit warnings that without immunity protection, future presidents would be subjected to partisan witch hunts and weaponized prosecutions by opposing political parties. The court's response was essentially that such concerns don't override the fundamental principle that no one is above the law. Don't go anywhere. The most explosive part is coming next. And here's what should alarm Trump's defenders. This isn't just about one criminal case or one former president. If any president could claim absolute immunity from prosecution for criminal acts committed in office, the entire system of checks and balances would collapse. Once that precedent is set, there's no turning back from constitutional monarchy. This puts Trump's legal team in a nearly impossible position. On one side, they face intense pressure from Trump and his supporters to continue fighting every legal battle with maximum aggression, regardless of the legal merits. That means appealing to the Supreme Court with increasingly desperate constitutional arguments that even conservative legal scholars are calling frivolous. On the other side, they must reckon with a federal appellate court that has now twice rejected Trump's immunity claims with language so definitive that further appeals border on sanctioning territory. The internal dynamics within Trump's legal team are reportedly fracturing under this pressure. Sources close to the defense tell NBC News that some attorneys are privately expressing concerns about pursuing appeals that lack constitutional foundation, while others argue that any retreat will be seen as abandonment by Trump and his base. Lead counsel John Luro reportedly held heated conference calls with co-counsel throughout the weekend, with some team members questioning whether continued immunity arguments could damage their professional reputations. Meanwhile, the financial implications are becoming staggering. Legal experts estimate that Trump's immunity appeals have cost upwards of $3 million in legal fees, with emergency filings, expert consultations, and appellate briefs consuming resources that could have been used for actual trial preparation. Former federal prosecutor Barbara McQuaid told MSNBC that the immunity strategy has become a very expensive delay tactic that ultimately strengthened the prosecution's position. And here's the tricky part. There's no credible legal defense remaining. Either the D.C. Circuit's immunity ruling is correct, in which case Trump faces trial without constitutional protection, or 12 federal judges appointed by both Republican and Democratic presidents have fundamentally misunderstood the Constitution, which would require believing that the entire federal judiciary has conspired against one individual. The ripple effects are already visible in other Trump criminal cases. In the Manhattan District Attorney's hush money prosecution, Trump's attorneys had planned similar immunity arguments for acts allegedly committed while president. Legal observers expect those arguments to be quickly abandoned following the D.C. Circuit's definitive ruling. The Fulton County, Georgia election interference case, where Trump faces state RICO charges, could see expedited proceedings as immunity delays are no longer viable. Perhaps most significantly, the Supreme Court's recent decision suggests little appetite for expanding presidential immunity beyond existing precedent. In Trump v. Mazars, the court rejected broad claims of executive privilege for former presidents. In Trump v. Vance, they explicitly ruled that sitting presidents aren't immune from state criminal investigations. The pattern indicates that even a conservative majority Supreme Court recognizes the dangers of absolute immunity claims. Legal and political analysts are calling this a constitutional watershed moment. Joyce Vance, former federal prosecutor and legal analyst for MSNBC, told reporters that the Rehearing denial closes the door on the most significant constitutional escape hatch available to Trump. She emphasized that while Supreme Court appeals remain technically possible, the unanimity of the appellate court's position makes reversal extremely unlikely. Do me a favor and slam that like button because it genuinely helps this video reach more people. Even Judge Michael Luttig, conservative constitutional scholar and former federal appellate judge, acknowledged that Trump's immunity arguments lack foundation in constitutional text, history, or precedent. He emphasized that while presidents deserve robust protections for official acts, those protections cannot extend to criminal conduct that violates federal law. So, let's break down what this actually means. First, the immediate legal impact is decisive. With no constitutional immunity protection, Trump's criminal trial can proceed on schedule without further delay appeals. Special counsel Jack Smith has already indicated readiness to begin trial proceedings on March 4th, as originally scheduled. This means jury selection, opening statements, and witness testimony will proceed without the months or years of delay that immunity appeals could have created. Second, it fundamentally alters Trump's criminal defense strategy. Without immunity protection, his attorneys must now defend the case on its factual and legal merits rather than constitutional technicalities. This means addressing evidence of election interference, witness tampering, and conspiracy charges directly rather than arguing that prosecution itself is unconstitutional. Finally, the political implications are staggering. A former president will face criminal trial during the height of presidential primary season with televised proceedings that will dominate news cycles and campaign coverage. Every Republican candidate will face questions about supporting someone under federal prosecution for election interference. Drop a comment below with your thoughts. I'm genuinely curious to see your perspective. But beyond the immediate political fallout, this is really about fundamental constitutional principles. The president's role as chief executive is sacred in our system of government. It demands putting the rule of law above personal interest and ensuring that executive power serves the Constitution rather than individual political survival. If presidents can claim absolute immunity from criminal prosecution, civilian control of government becomes a meaningless concept. This scenario is causing sheer panic within Trump's inner circle. Reports indicate that senior advisors held emergency conference calls throughout the weekend to determine next steps. Some argued for immediately appealing to the Supreme Court with expedited briefing schedules, claiming that only the highest court can definitively resolve presidential immunity questions. Others insisted that further appeals would only delay the inevitable while creating additional legal expenses and public relations disasters. The strategic disagreements reportedly became heated during a Saturday evening conference call that included Trump himself. According to sources familiar with the discussions, Trump repeatedly interrupted legal explanations to demand more aggressive tactics. At one point, asking whether he could fire federal judges the way he had fired FBI Director James Comey. Senior advisor Jason Miller reportedly had to explain that federal judges serve life tenure and cannot be removed by political pressure. The psychological impact on Trump's inner circle is becoming increasingly visible. Former White House Chief of Staff Mark Meadows, who faces his own legal challenges in the Georgia election case, has reportedly distanced himself from Trump's immunity arguments, telling associates that some battles can't be won in court. The distance represents a significant shift for someone who previously defended Trump's most controversial decisions. Meanwhile, Trump's core supporters are absolutely furious at what they see as judicial persecution and constitutional coup attempts. Social media platforms are flooded with calls to primary any Republican who fails to defend Trump against weaponized justice. They view the immunity denial as ultimate proof that the entire federal judiciary has been corrupted by Democratic operatives determined to prevent Trump's return to power. The base's reaction has created additional pressure on Republican primary candidates who must navigate between legal reality and political loyalty. Florida Governor Ron DeSantis attempted to thread the needle by arguing that while no one is above the law, the timing of prosecutions raises legitimate questions about political motivation. Former UN Ambassador Nikki Haley took a stronger position, stating that presidential immunity has constitutional limits that even former presidents must respect. Things escalated further when Trump himself responded with a series of Truth Social posts throughout Martin Luther King Day weekend. He called the Rehearing denial another rigged decision by activist judges trying to interfere with the 2024 election. He claimed the immunity ruling was totally unprecedented and unconstitutional while promising to fight this witch hunt to the Supreme Court and beyond. The posts included personal attacks on individual judges, naming Chief Judge Sinason, and questioning his loyalty to America in language that legal ethics experts call deeply inappropriate. Stay with me. What comes next will completely change how you view the legal landscape. Here's what makes Trump's response even more damaging to his position. Instead of addressing the constitutional merits of immunity arguments, his reaction focused entirely on attacking the judges and claiming persecution. When your defense strategy consists of attacking the integrity of federal judges rather than defending your actions on legal grounds, you've essentially conceded that the law isn't on your side. Constitutional law experts immediately flagged the dangerous precedent of attacking federal judges for applying established legal principles. Frank Bowman, professor at the University of Missouri School of Law, told Politico that attacking judges for ruling against you is exactly the kind of behavior that demonstrates why immunity protections shouldn't extend to criminal conduct. This goes far beyond one criminal case or one former president. It's about whether the United States will maintain a system where no individual, regardless of political power or former office, can claim to be above the law. If former presidents can delay prosecution indefinitely